Happy Friday, everybody. It's hashtag FAQ Friday live from AJ Lakes HQ in Windermere. And there's been a lot of talk this week about the Employment Rights Bill 2024 introduced by the UK government, and it is designed to significantly enhance worker protections, marking one of the most substantial overhauls of employment law in recent decades. So I've had lots of questions this week, and I have just been very privileged to be on an amazing webinar where it's given summaries, explanations of the new Employment Rights Bill 2024 by JMW in Manchester. They're great legal experts, and they have just provided a superb webinar all about it, and they've got a series of webinars coming very, very shortly to help and support you, so watch this space. I'll put all the details in the link below. So I thought it was ideal to provide you with a summary of the key features and implications for employers to help and support you in your business. So the key features of the Employment Rights Bill 2024 is, from day one, employment rights. Employees will now have protection from unfair dismissal from their first day of work, removing the previous 2-year qualifying period. It applies to approximately 9 million workers. Flexible working as a default is number 2 summary. The bill makes flexible working the default unless employers can demonstrate, which I'll mention very shortly, that it's unreasonable to accommodate such requests. Employers must provide valid reasons for any refusals, and I have got 8 of these valid reasons for refusals, which I will go through shortly. The third one is enhanced family leave rights. The bill introduces day one rights for various types of leave, including paternity leave, parental leave, and bereavement leave. We haven't got clarification of what the bereavement leave is for right now. That's still undergoing consultations and discussions. It's not very clear. But this aims to provide better support for employees during significant life events. Number 4, 0 hours contracts reform. Whilst not outright banning 0 hours contracts, the bill requires employers to offer guaranteed hours after a certain period, ensuring more stability for workers. And what we understand out of this is that it would be over a period of time, but it's not yet been clarified what that time frame is. So it would be guaranteed hours of what they have been working, but there's not a time frame, whether it's 12 weeks or what, we're not actually sure, because it's all still to be ironed out. Number 5, a ban on fire and rehire practices. The bill prohibits dismissing employees simply to rehire them under less favourable terms. So that's a no-go now, and employers can only dismiss for variations that combat significant financial difficulties. Basically, from what we understand, is that unless the business is going to go into financial ruin, then you cannot dismiss an employee for a change of contract. So it's all a bit up in the air at the moment. It's not been clarified exactly what the details are. Number 6, statutory sick pay, the SSP. The bill eliminates the 3-day waiting period for SSP, allowing employees to receive pay from the first day of illness. Number 7, creation of a fair work agency. So this new agency will consolidate various enforcement roles and oversee compliance with employment rights, including holiday pay and minimum wage regulations. Reasonable grounds for refusing flexible working are the following. I mentioned there's 8, I'm not sure whether I mentioned, but there is 8 reasonable grounds for refusing flexible working within your organisation. So employers can refuse flexible working requests based on one or more of the following 8 reasonable grounds. These all can be found on the government website, by the way. Number 1, burden of additional costs. If accommodating the request would lead to significant financial strain, you can refuse. Number 2, detrimental impact on quality of work. If the change could negatively affect the quality of service or output, you can refuse. Number 3, inability to meet customer demands. So this was something that came up with our hospitality industry, saying that if somebody wanted to have a flexible working when they had to be there for a customer, say a breakfast service, how would that work? So this is actually a reasonable refusal. If the request hampers the ability to serve customers effectively, you can refuse. Insufficient work during proposed times. If the requested flexible hours are not conducive to the nature of the work. Number 5, planned structural changes. If there are impending changes in the workforce structure that may conflict with the request, you can refuse. Lack of suitable cover as number 6. If there's no viable alternative to cover the employee's duties during the requested hours, you can refuse. Impact on team dynamics. If the change could disrupt team cohesion or dynamics, that is another reason to refuse. Number 8, operational difficulties. General challenges that may arise from adjusting to a flexible working pattern, you can refuse. So in summary, the Employment Rights Bill 2024 aims to modernise the employment landscape, offering greater protections and supporting flexible working. Employers need to adapt their policies and practices to comply with these new regulations, whilst balancing operational needs. For detailed insights, you can refer to the sources on the UK government's websites, but I also want to highlight the JMW, which I'll give you the email, the website address, which is www.jmw.co.uk, and they've got up and coming webinars, a series of webinars hosted by JMW solicitors. You can visit their events page. They frequently offer webinars on various legal topics, including the recent Employment Rights Bill. For instance, there's an update webinar that I've just been on this morning, and the experts discuss the implications, answer questions on the new legislation. If you want to RSVP them, or you need more details, you can email them at marketing@jmw.co.uk or give them a call on 0345 872 666. Their offices are located in Manchester, London and Liverpool, and you can find their contact details and further information about their services on their website www.jmw.co.uk. I am going to ask Laura Poynton of JMW to come in for a showcase Sunday and actually discuss this particular employment's right bills, but I'll just grab my notes because there is another bill, the legislation that's come in, and it's really important, and it is the sexual harassment element of the Employment's Rights Bill 2024. But the duty to take steps to stop sexual harassment is actually coming in on the 26th of October this month, 2024. And you must take all reasonable steps to prevent sexual harassment in the workplace, but also take all reasonable steps to prevent third-party sexual harassment in your workplace. So it does affect an employer for third-party sexual harassment as well. And it is coming into force on the 26th of October 2024. And if the employer doesn't take all reasonable steps, they'll be subject to uplift of 25% of compensation. You might have policies, you might have training, but if you've got managers and supervisors who are in charge of employees, do they know the policies and procedures? Have you undertaken a risk assessment? And make sure you do this before the October deadline. So there's lots of information there, lots more to come from JMW and lots of other legal practices around the UK to help and support you. But check out the government website, and there's lots of questions being asked of me at the moment of how can we get involved, how can we communicate. It is a bill that's not fully completed, and from what I understand, that they are waiting for the chance to have royal approval, and this will be done. The commencement of the bill is when royal assent is granted, and then it will come into force. It could be a stage process. There's talk that it could come in later this year, early next year, or within the next 2 years, 2026. It's not confirmed as yet, and a lot of provisions will need proper consultation. So if you want to get involved and you want to lobby, please contact your MP. Please actually get involved by writing to the government. You can actually contact your lobbying. So if you in the hospitality industry, contact UK Hospitality, contact your local tourism board, and make sure that, or your local councils, make sure you're in Cumbria, Enterprise in Cumbria, contact them, or contact people like me, and we'll put you in touch with the right people to be able to lobby and put your point forward of what it will mean, so that it will help to navigate the bill a lot easier. A lot of this will not be in right now because they've got people to consult with to make sure that it is effective in the workplace, but also effective in the UK. So I hope that's helped and supported you. As always, I'd be really grateful if you like what you hear and see, to subscribe on my YouTube channel so that you will hear more about top tips and frequently asked questions answered by myself at ajlakes.com. Please, if you've got any questions you want answering or any contacts that you want to be referred to, it's Alison at ajlakes.com, but message me direct on any of my media channels. So please like and share. Sharing is caring. Anybody who's got any questions on this, certainly we'll put the details at the bottom with regard to the legal status to help and support you and your business moving forward. May I wish you a happy Friday, everybody, and a happy weekend. Take care, and thank you for listening. Bye-bye.